mention that we did originally hope this event to be a debate between Professor Collett and another faculty member. However, we reached out to over 10 people, think tanks, lobbying groups, and all of them either refused to debate Professor Collett or just ignored my emails. Very disappointing, but we know Professor Collett is an amazing speaker, and we're all very excited to have her today. I would like to thank one of our co-sponsors, our only co-sponsor actually, Thomas More Society, Ben Janicek. We really appreciate the crew that we have on Thomas More and for co-sponsoring this event. With all of that said, thank you all for joining us again, Professor Collett. We're really excited to have you speak. And then Hannah Elizabeth, if I could have you introduce her. Without further ado, Professor Collett.
Teresa Collett is a professor at the University of St. Thomas Law, where she serves as the director of the school's Pro-Life Center. Collett received her doctorate at the University of Oklahoma College of Law. As a well-known advocate for the protection of human life and the family, Collett specializes in the subjects of marriage, religion, and bioethics in her research. She has published numerous research articles and is the co-author of a law casebook on professional responsibility and a co-editor of a collection of essays exploring Catholic and Catholic perspectives on American law. She's an elected member of the American Law Institute and has testified before committees of the United States Senate and the House of Representatives, as well as before legislative committees in several states. In 2009, Pope Benedict XVI appointed Collett to serve a 5-year term on the Pontifical Council for the Family. Her appointment was renewed by His Holiness Pope Francis until 2016, where the responsibilities of the council were assumed by the Dicastery for the Laity, Family, and Life. In 2013, she served as a delegate to the International Conference on Population and Development for the Mission of the Holy See to the United Nations. She represented Congressman Ron Paul and various medical groups in the defense of the U.S. federal ban of partial birth abortions and the governors of Minnesota and North Dakota defending the NH requirement of state parental involvement prior to performance of an abortion on a minor before the U.S. Supreme Court. Collett is also often asked to represent the interests of government officials before federal appellate courts. She has served as a special attorney general for the states of Oklahoma and Kansas, as well as assisting other state attorneys in general in defending laws protecting human life and marriage. Prior to joining St. Thomas in 2003, Collett taught at the South Texas College of Law, where she established the nation's first annual symposium on legal ethics. Professor Collett.
Thank you so much. I'm delighted to join you all today, and I'm really grateful. And I know that Sydney's efforts were almost heroic on trying to find someone to at least dialogue with. And I recognize that dialogue versus debate is an increasingly rare instance in American political environment today. But having said that, I think there's an open question about, as our title indicates, will Roe survive to see its 50th birthday? Of course, it's the 48th anniversary last January of Roe versus Wade. And so if you'll forgive me, because I think PowerPoints are really helpful, because a talking head for even 45 minutes is a bit much, especially if you've Zoomed all day, as the upperclassmen apparently have, like at our law school. And I'm happy to make the PowerPoints available to folks afterwards for their own individual study. So I'm going to go ahead and share my screen and give you a little bit of background. And as soon as the host allows me to share my screen, I will pull up my PowerPoints, or perhaps Sydney will use hers. The problem with Sydney doing it is I can't advance them individually. So hopefully, in just a minute, I will pull up the PowerPoints.
Yeah, no worries. Professor Collett, do you have access to the button share screen to?
I do, but it says host disabled participant screen sharing.
Okay, let me see if we can go ahead. Becky,
can you make me co-host?
Yeah, could I have you make her a co-host instead of a panelist? Yeah, I can't promote myself.
I'm working on it, sorry.
Okay. No worries, thank you.
That's okay. I was telling my students today in class, I have a very dear colleague who retired in December simply because of a variety of health concerns and stuff. And when I said yes, he called me yesterday for technological assistance, the students laughed out loud. I wasn't sure what to, actually, I was entirely sure what to make of it, which is why I told the story.
So
But
it's
let's
giving
see.
me the option to make you the host. It doesn't have a co-host option. So I'm going to do, is that all right that I
Perfect.
go ahead and do that? Awesome.
I'll surrender it as soon as I finish my prepared remarks. All right.
All right,
Thank you
perfect.
so much.
Thank you, Becky.
You're very
All
welcome.
right. Let's go here. But what I want to do is not make you look at all my notes along the side. So let's see if we can do that. Yep, there we go. Perfect. All right, maybe that's why my friend called me for technical assistance yesterday. Anyway, so of course, the question I think we're all really interested in, whether you believe abortion is a human right based on women's autonomy, or like I believe that abortion is in fact anathema when we think about human rights, because the conception and implantation of a human child within a woman's womb should vest it with certain protections and certain rights under the legal system. So let's talk about where are we at and how do we, progress in this. So let me see if I can get there. I think I can.
Professor Collette, I'm sorry to interrupt, but we can see the screen with any notes that you write. We could potentially see them on the side. Could you hit F5 on your laptop, and then maybe that
I
would
thought I did, but let me
give you full
try.
screen?
Thank you for bringing that to my attention.
No worries.
What I'm looking at is no notes.
Okay.
Are you?
Yes, we see the next slide coming up, but we don't see any notes written underneath it. I was just thinking if you hit the next slide, would notes come up? Yeah, we can see your notes now.
That actually doesn't trouble me.
Okay, perfect.
Because I use that to provide my sources, which is part of the reason I feel comfortable providing the slides to students who are viewing this. I want to make sure that they themselves have the opportunity to sort of, well, is what she said right? Does that make sense?
Awesome.
And I'm very comfortable with that. So
That's
thank
perfect.
you.
Thank you so much.
So let's begin with sort of, at least for many law students, and certainly for many members of the public, sort of the history of Roe versus Wade, because many law students simply do not know that the question that the court accepted certiorari on arose out of a very different procedural history and actually brings into question whether the court should have ever reached the constitutionality of abortion per se. And so this slide sort of walks us through that. And it's titled, giving away my evaluation at the end of the day, Political Machinations in the Guise of Constitutional Analysis. The district court in Roe declared that the Texas abortion statute, which of course was the basis of the lawsuit, was unconstitutionally vague and violated the Ninth Amendment of the federal Constitution. Notwithstanding that decision, the court declined to enjoin enforcement of the law based on the federal doctrine of abstention, which was understood at the time to be limited to cases involving First Amendment rights. Now, for the first-year law students that are watching, you may or may not have reached the doctrine of abstention in your civil procedure class, but it was the idea that because of the system of federalism, there are only so many areas of judicial intervention by federal courts into state proceedings. And so we had a state trial court case dealing with the constitutionality of Roe. And then it wasn't a removal question per se, because then the whole case would have been in the federal court. But instead, it was because they were claiming that a federal right was violated by the Texas law, that they had the right to reach out to the federal court and have the federal court decide whether the federal Constitution encompassed abortion or not. But it was not at that point in history, when the case is going through the trial court, decided that federal courts could intervene. In fact, they had to typically wait. So the appellate procedures of the rule at the time did not allow direct appeals to the Supreme Court from the grant or denial of declaratory relief alone. In other words, under the rules of appellate procedure, they couldn't reach the question of whether or not the Texas abortion statute was unconstitutionally vague and violated the Ninth Amendment. However, they could reach the question of whether or not an injunction was the proper remedy. And so the Supreme Court was asked by both Jane Roe and the intervening Texas doctor whether the trial court erred by denying the injunction. Once the court had decided this is an unconstitutional law that said, I'm not going to enjoin it because that's too much interference in state sovereignty, whether or not that was permitted under the Supreme Court rulings defining the parameters of the abstention doctrine. Now that sounds really much less sexy and much more boring than sort of the, is abortion a constitutional right? But as those of you who have had constitutional law already in law school know, that's true of many constitutional doctrines. They simply don't carry, at least initially, the sort of emotional impact and heat that the public dialogue does. And this was initially a procedural question and a procedural problem. So the court had, during the pendency of this, provided some clarification on the law regarding abstention in 1971. Now remember, Roe came down in 73, but Roe's opinion was held for at least a couple of months because they didn't want to interfere with the national election. That's why it came out in January instead of earlier in 1972. And the opinion of Younger v. Harris determined that, in fact, there were some parameters governing federal courts' intervention in state proceedings. And based on that ruling and prior opinions, the scope of direct review, the court could have, and Texas argued should have, declined the direct appeal based on the failure to grant an injunction and awaited the resolution of the merits that actually had been properly appealed to the Fifth Circuit. So we have this very odd situation where you've got a trial court splitting the judgment saying that, yes, this law is unconstitutional, but no, I'm not going to enjoin its enforcement. And under the appellate rules at the time, the second part of the opinion going straight up to the US Supreme Court, but the substantive part, the first part of the opinion, going to the Fifth Circuit. Instead, on April 22nd, 1971, the justices voted to hear both Roe and a separate case that was ultimately paired almost as a companion case, Doe v. Bolton, involving, at least on its face, a statutory construction question. This procedural peculiarity, the court acknowledged and dismissed in the first section of the Roe opinion. Now, I suspect that's not in your con law books, which carry only redacted versions of the opinions, but they actually treat this issue in the first 2 or 3 pages because it was a procedural oddity, which itself makes you wonder, well, why didn't they just await the Fifth Circuit? In addition to that, there were numerous other opinions of federal district courts making their way through the appellate process, some even ahead of the Roe timeline, regarding the constitutionality of the abortion procedure itself. But instead, for whatever reason, this is the case that got selected. Many scholars attribute this decision to disregard the rules of appellate procedure to the desire of Justice Brennan's, Douglas, Marshall, and Stewart to legalize abortion. Now, that's only 4 out of 9, but their ability to do so was facilitated by the unexpected retirements of Justices Harlan and Black, resulting in a unique 15-week period between September of 71 to January of 72, again, not 73, but when the court was shorthanded because of 2 vacancies, and a block of 4-3 could rule effectively on the substantive question via the procedural issue. Okay, so for non-lawyers, this is like a snooze fest. But for lawyers, it signals something very odd. Why is the court disregarding its own rules? Why is it not awaiting sort of the laboratory of the states, and in this case, the laboratory of the circuits? You have cases making their way through the federal courts of appeals to allow a greater articulation of the arguments and a greater judgment about how good judges rule given the various procedures. But what also makes this a very odd case is there is absolutely no evidentiary record, a point I make in this next, before we get to this next slide. Now, one of the problems, and not only am I a tenured full law professor, but I also engage in, as the introduction indicated, abortion litigation. And one of the oddities of this sort of litigation is that a majority of the court's opinions in the area of abortion really don't have developed evidentiary records. And yet, so many of their opinions appear to be deeply grounded in what they perceive to be the facts. Well, where do they get those facts? They get those facts from amicus briefs. And what's the difference between facts presented in an amicus brief and facts presented at a trial court? They're not subject to cross-examination. So yes, you may have dueling amicus briefs, but you don't have the scrutiny that occurs in the adversarial process in the trial court. And so a lot of abortion jurisprudence is based on the court's determination of, if you will, the facts of abortion, based not on actual evidence that's been tested by the process, but rather based on declarations, affidavits, citations, and amicus briefs. And that's a very odd situation in such a fact-intensive area as abortion. So not only do we have the procedural peculiarity of Roe, but we have the evidentiary peculiarity of Roe. And particularly in light, if you look at the cases in the pipeline to the Supreme Court in 1971, 1972, they actually could have accepted cases that had a much more developed evidentiary basis. But that's not the choice that was made. Let's fast forward then to Planned Parenthood versus Casey. So we know that Roe was influenced by clear maneuvering to take a case by 4 of the justices who thought the case could get through and that could be resolved in a 4-3 majority. But the case was re-argued and it ended up with 9 justices rehearing the case with new briefing, new argument. And now let's fast forward to the next major case, which is Planned Parenthood versus Casey. Jeffrey Toobin has, in his book, The Nine, sort of recounted the history about how Planned Parenthood versus Casey turned out the way it did. And I will tell you, both the pro-choice side and the pro-life side invested hundreds of thousands of dollars gearing up for this case. This was going to be Armageddon. This was going to be the case in which either Roe was going to be reversed or Roe was going to be preserved. And the confidence of the people who believed that Roe was bad law, which was actually the consensus of all legal scholars, including pro-choice scholars who liked the outcome very much, but thought the rationale was not grounded in the Constitution and unpersuasive, right? The pro-life side actually had the dominant side of that pre-decision conversation. In fact, the lawyer who actually argued Planned Parenthood versus Casey said after the argument and subsequent to the opinion, I thought we were going to lose. And so their strategy was to, in addition to presenting the best legal arguments they could, to build political pressure, to warn the court that to abandon Roe would create, well, to quote Senator Schumer, would reap the whirlwind, that it would be seen by the public as an abandonment of principle and the ultimate politicization of the judiciary. Obviously, a view not shared by the pro-life side, but a view that ultimately was very effective. So here's how Jeffrey Toobin describes what happened. Once before Justice Kennedy joined the court, he had actually called Roe, and I quote, the Dred Scott of our time, close quote, a reference to the infamous 1857 ruling that sanctioned slavery and helped spark the Civil War. Kennedy thought there was a nobility in judging, and saving Roe would show the world that the justices were something more than a mere politicians. A statesman's compromise suited both Kennedy and Kennedy's politics and his conception of the role of the judge. So his initial position before sitting on the court was that Roe was, in the words of my colleague, Michael Paulson, the worst constitutional decision of all times, close quote. But the integrity of the court, the public perception of the court was very important to Kennedy. So Kennedy signed on with Souter and O'Connor. His was the most dramatic switch of the three because it had been only 3 years since he'd voted with Rehnquist in the Webster opinion that advocated overruling Roe. Even more dramatically, Kennedy had clearly supported Rehnquist at the conference in Casey, that conference in which the justices assess what is your initial evaluation of the case, who should write the opinion, what sort of, taking the temperature of the case and assigning writing the opinion. At the conclusion of the initial conference on the case, Rehnquist, believing that he had the support of Justices White, Scalia, Thomas, and Kennedy, plus his own, that's 5, assigned Casey to himself, intending to write an opinion that allowed states almost a free hand in regulating abortion. As a practical matter, Roe would have been overruled, but not in so many words. So, sorry, it's not. Judicial opinions seem to matter. Let me see if I can we'll go up here perhaps and see if that works. This is the problem with sharing a screen. I think I'm going to do it this way and see if I can do it here. There we go. All right. So judicial appointments matter. Of the 3 most recently appointed Supreme Court justices, 2 have been subjected to what I would characterize as religious bigotry and unproven and incendiary sexual accusations during the confirmation hearings. And you can see Justice Gorsuch went through the confirmation hearing rather unscathed. But it was, of course, Justice Kavanaugh who received claims that he had engaged in sexual misconduct. And while Justice Barrett did not actually get attacked during her Supreme Court confirmation, her appellate court confirmation, as many of you all will recall, had the famous quote by Senator Feinstein where she asked her if the dogma lived deep within her. Now, I have to confess, I actually have a coffee cup that says the dogma lives deep within me. But it's that sort of, there's something wrong with being a sincere religious believer that should preclude you from the US Supreme Court that incentivized a lot of people during the 2020 election, I've got to say. And I'm sorry, not 2020, but 2020 and 2000, the most recent election. So that sort of concern, the Supreme Court drove a lot of voters both ways. Okay, so Roe is the law of the land, but it is increasingly seen as being at risk because now we've got Justice Thomas, who's on record to overrule Roe, Justice Alito, who's on record to overrule Roe, and a presumption that Justices Gorsuch, Kavanaugh, and Barrett are willing to overrule Roe. So what are these efforts that are occurring? Well, after Roe versus Wade was decided in 73, there were a large number of constitutional amendments that were introduced into Congress to overturn that decision. So both sides have tried to overturn it through Congress, including 37 U.S. House resolutions by members of the Minnesota congressional delegation, where I live, a very liberal and very pro-choice state. In fact, we don't even have a post-viability ban in the state. It was struck down soon after Roe versus Wade, and we've never been able to legislatively correct that. So in fact, in the state of Minnesota, it is still legal to abort a child at 9 months of pregnancy. But when we look at these sort of different pro-life amendments that have been proposed, there are 6. One are life protective amendments that provide explicit protections to unborn persons. The second are paramount amendments that declare the right to life to be paramount, and therefore, to the extent there are equal protection arguments, a la Justice Ginsburg, due process arguments, a la Casey, that when those two are in conflict, the right to life will trump. There are prohibition amendments that directly prohibit the performance of abortion in the United States. There are personhood restoration amendments that declare that a human being shall be deemed to be a constitutional person at the moment of birth. The most common, though, and the ones that we actually see at the states most regularly, are reversal or abortion neutrality amendments, which simply say that abortion is not a matter of constitutional law, leaving it to the political process. There are state legislative amendments that take all of these different positions. And in the first year, 10 years after Roe, Congress were actively considered a variety of types of amendments, at least through committees, but only one made it to the floor. And it was in 1983, after 2 days of debate, that the Hatch-Eagleton human life proposal came forward. And it lost by a 1-vote margin, okay, as far as if we required a majority. But in fact, to put something on the ballot as a US constitutional amendment, you need 2/3, as law students know, and therefore it fell short by a more substantial number. I believe the number was 18. Okay. So were the other branches of government quiet during this period? Absolutely not. From 83 to 92, the US Solicitor General asked the Supreme Court to overturn Roe 4 times, and it was rejected, and the cases are listed here for you. And in the most recent June medical case before the US Supreme Court, 207 members of Congress filed an amicus brief requesting that the court uphold the Louisiana statute related to physician privileges, that you have to have privileges at local hospital to admit patients who might have been injured during an abortion, and to take up the issue of whether Roe and Casey should be reconsidered. So it's not like any of the branches of government have been quiescent in this area. So then we come to this year. And on the 48th anniversary of Roe versus Wade, we have a statement by President Biden and Vice President Harris on the 48th anniversary of Roe. And I quote, "In the past 4 years, reproductive health," let me go back. I'm trying to, maybe I won't. Reproductive health and the right to choose have been under relentless attack. We're deeply committed to making sure that everyone has access to care, including reproductive health care, regardless of income, race, zip code, or insurance status, or immigration status. And the Biden-Harris administration is committed, and here's the important phrases, of codifying Roe versus Wade and appointing judges that respect foundational precedent like Roe. So there's the challenge, right? You've got concerns that because it is possible that there is a 5-4 majority to overturn Roe versus Wade, due in large part to the appointments of the prior administration, that the challenge is how to preserve it. And the Biden-Harris administration has said we're going to do so through codification, through Congress. Now, what's interesting about this statement is I think its intent was to discourage the court from overruling Roe versus Wade. I think its intent was to make a political statement about how committed the current administration was to reproductive rights and to discourage the court to take any steps beyond June Medical, which arguably restored the Casey standard instead of Texas Women's Health, which was a standard that made upholding state regulation of abortion more difficult. I think it was intended to sort of say to the court, don't you dare, we will pass legislation. But what I find really interesting is when we think about the Chief Justice Roberts, and Justice Gorsuch, who very often votes with Chief Justice Roberts, it seems that it could possibly have the exact opposite effect. If you, like I, at least given the current political environment, believe that the best possible outcome we can hope for is simply returning the abortion issue to the political process. And yes, that will result in a patchwork of states, just like we have in so many other areas. Then that's great. And if Congress wants to intervene and if they have adequate authority through the Constitution, that takes the pressure off the court. The court no longer has to be, in the words of Justice O'Connor, the National Abortion Control Board. That's perfect. And so I can't help but wonder about the wisdom of the president's statement. It does strike me that it's a little odd, but this is the statement they made. Can they make good on that threat? And that's a question that certainly both sides are actively concerned about. Well, let's begin with how likely is Roe to be overturned? Well, frankly, you don't have to have a case directly challenging Roe. You could have a case like Texas Women's Health or June Medical about regulation of abortion. And the court could simply say, because the lower court's opinions were premised on Roe versus Wade and Planned Parenthood versus Casey, this court must evaluate the legitimacy of that precedent, and away we go. So this thought that we have to pass state legislation, like personhood legislation, that directly challenges it, seems not to be correct. And in fact, several commentators, including the Kaiser Family Foundation, which is a very prominent foundation in public health care, but very pro-choice, has identified two potential cases in which this could occur. The first is the FDA versus Acog. Now, this case has already been resolved, and they chose not to do it at that point. But it had challenged the FDA's rule that as a predicate to prescribing the abortion pill, that you had to confirm the pregnancy and do a physical exam. Now, ultimately, the US Supreme Court said that that sort of requirement is constitutional, not necessarily mandatory, but constitutional. And therefore, the FDA was within its scope of authority. So that one's off the table. But here's the really interesting one, and the one that I'm so curious about what's going on in the court. And I desperately wish I were a clerk right now so that I could at least have some sense of what's happening. Dobbs versus Jackson Women's Health Organization. It's a 15-week ban passed out of Mississippi. And at one level, it seems fairly outside of the United States, normal. I mean, you've got 14-week bans in a number of European countries. And the vast majority of abortions, even in this country, occur between 8 to 12 weeks. So how many abortions would it really impact? But the petition has been pending before the US Supreme Court for certiorari since June 15th of 2020. And again, in the recent conference on which cases to accept and which to reject, the Supreme Court held it over until Friday. This is very odd. And if you want to keep track of it, SCOTUS blog is great. And it actually works really hard to be balanced. So it's sort of one of my favorites. But what I really like it for is it has all the primary materials. I can actually see the briefs that are filed. I can read the opinions there. So I don't have to accept their commentators, of which I've been one, and some of your faculty have been one. So I like SCOTUS blog's commentary very well, but what I like most is it gives me the primary materials. And Dobbs versus Jackson's Women's Health is just a very odd case that they keep carrying over, which leads me to believe that the justices, at least the justices that would like to see some change in Roe and Casey toward the pro-life side, are trying to observe more than, quote, the rule of three, right? Obviously, cert petitions need 4 votes to be granted. And often prudence would dictate that you wait till you know that you have a 5th, as much as Justice Rehnquist knew that with Kennedy's vote, he had 5. But nonetheless, you don't want to accept cert on a case like this that will simply reinforce Roe and give greater strength to this idea that the Democrats invoke every confirmation hearing, that Roe is, quote, super precedent. You want to wait till there's something that you can actually make progress on. And so to me, it's extremely curious that we are 9 months out, no pun intended, and still don't know what the court's going to decide in this case. It's a very odd case. And so I think Kaiser Family Foundation probably has it right. It's one to watch. But that's not it. What Biden said is we're going to codify if you reverse. So let's look at what the codification possibilities are. Well, we have the Equality Act, which of course is most directly concerned with sexual discrimination. And in that case, and I'm only going to talk for a little bit longer because I want to have ample time for questions and answers. But in that case, they define public accommodations to forbid discrimination in any establishment in particular that provides health care services. It's not limited to physical facilities and places, and they define sex to include pregnancy, childbirth, or related medical conditions. It also states that pregnancy, childbirth, or related medical conditions shall not receive less favorable treatment than any other physical condition. So we've got abortion swept into the Equality Act by virtue of its definition of physical accommodations. We also have it swept into the act because of the bill's particular provisions regarding federally funded programs and activities. It forbids discrimination on the basis of sex, including gender, sexual orientation, but it defines pregnancy, childbirth, or related medical conditions as part of sex discrimination and brings us back to this idea that it shall not receive less favorable treatment than other medical conditions. So quite possibly, the Equality Act could be used to attack any regulations of abortions, generally to the extent that something's a public accommodation, all right, which almost all hospitals and clinics are, or to the area of publicly funded, which takes us to the abortion funding issue and the Hyde Amendment. So because of that, and because there is no abortion neutrality language, the Equality Act, and not just because of that, but one of the objections of the U.S. Conference of Catholic Bishops and many pro-life people is that this particular bill is a Trojan horse, or at least one of its harms is the fact sorry, I don't know how to turn off my other phone. But one of the concerns is that it's a Trojan horse to actually eliminate any ability of states to regulate abortion. So, and in the memo by the USCCB, they state, for years, it's been an accepted predicate. It's been an accepted predicate in federal bill drafting forbidding discrimination based on sex to have abortion neutrality language to blunt any inference that non-discrimination requires the provision of abortion. And the bishops cite both the Title VII and Title IX. And then they say that the fact that it appears in this context and doesn't appear in the Equality Act will be used in court to establish that the failure suggests that it should apply to abortion. The same reading and conclusions applies to the anti-discrimination related to federal funding. And so this analysis is persuasive to me. It's the normal lawyer's analysis we see in litigation. But that's only one bill that could, in fact, quote, codify Roe. But more than codify Roe, could radicalize the area of abortion regulation in terms of removing viability limitations, physician-only requirements, parental involvement, any number of other regulations that enjoy broad public support. The one that I'm actually most worried about, although the actions of Congress yesterday give rise to some concern that is reaching a little higher level, but the one that I'm most concerned about is the successor to the old pro-choice bill. And this is HR 2975 that we'll see resurrected again. It's been introduced into multiple sessions. And at the time it was introduced, now Vice President Harris, then Senator Harris, was one of its most enthusiastic supporters. So what's the bill say? The bill prohibits state and local governments from imposing certain regulations on access to abortion services. And specifically, it requires, and let's look at these individually. And this is from the Congressional Research Service, not the USCCB, not the National Right to Life, and not Guttmacher or Planned Parenthood International or the National Planned Parenthood. So what can states not do? Well, they can't require unnecessary tests or procedures in connection with the provision of abortion services. And these comments are mine, right? Like ultrasound requirements or physical exams for prescribing medical abortion. And then I cite you to the FDA case that Kaiser was worried about. Now, ultrasound may seem greatly intrusive, especially if you are a Virginia resident and heard the debate that they had at one point about whether or not to pass an ultrasound requirement. But the simple fact is that published research that has been provided by clinics in survey materials indicates that well over 90% of all abortions are preceded by an ultrasound. Why is that? Because you want to make sure that the pregnancy is intrauterine. You don't want it to be an ectopic pregnancy because the abortion won't do any good. And you want accurate gestational dating. Why is that? Because the gestational dating of the pregnancy tells you what technique is the safest for the woman and the most medically efficacious. For example, medical abortions, or what some people call chemical abortions, drug-induced abortions, are of less efficacy the later you go in pregnancy. So you really want an accurate gestational date, and you want to know that it's intrauterine. That's the point of the ultrasound. The fight over the ultrasound bills typically, although ostensibly for public consumption, is about the requirement that a woman undergo this intrusive procedure, is in fact about the requirement that the woman be shown the ultrasound as it is being taken. No different than the way we treat many x-rays. So this would make such requirements illegal under federal law. the same health provider who provides abortion services cannot be required to provide such tests and procedures. So the doctor who actually provides the abortion would not necessarily be required to provide certain counseling or to perform the ultrasound itself or to perform other tests and procedures. It also would prohibit providers being required to offer what the legislation says is medically inaccurate information to patients regarding abortion services. And of course, my reference here is to the case out of North Dakota where, and it really is somewhat remarkable, the American Medical Association has filed many an amicus brief, but it is a rare situation where they have actually been a party to abortion litigation. And in this case, the AMA sued the state of North Dakota because it was requiring that women who were undergoing a medical or chemical abortion, drug-induced abortion, be informed that after taking the first medication, but prior to taking the second medication, that it was possible to continue a viable pregnancy to completion with a healthy birth, the abortion reversal procedure. And because there was only limited data that had been published that supported that statement, the AMA said this wasn't evidence-based medicine and therefore you couldn't require them to report that. We'll see how that case comes out. There's currently some significant research going on in that area about whether or not you can actually reverse the abortion, the effect of the first abortion medication or medication provided for purposes of abortion. Providers to refrain from prescribing certain drugs. The FDA has certain requirements, including if you are going to prescribe the abortion pill for purposes of abortion, you have to be competent to surgically perform an abortion in the event that it fails, because the pill itself is pterogenetic, which means that if it is unsuccessful in ending the pregnancy, it will more likely than not actually cause birth defects and disabilities in a child that is born as a result of that pregnancy. And so the FDA has some very strict regulations in that area that would no longer be available, at least arguably. Require hospital facility agreements, that's June Medical. Require one or more medically unnecessary in-person visits. This has been a point, the waiting periods in the area of constitutional law in abortion has been a long debated possibility. But what makes abortion unique is it's incredibly rare to go into any sort of medical provider, have them diagnose your condition and immediately be willing to provide you some sort of surgical intervention. For the most part, if you go in and see a physician about a particular condition, and the physician gives you various options, including a surgical intervention, you have to reschedule. You have to come in at a later period of time. From the pro-choice side, that's a burden because women may be traveling from rural areas or from other distances or may not be able to take off work, et cetera, et cetera. But from the perception of those of us who disfavor abortion, it simply equalizes abortion services to many other services that are provided with surgical intervention. And finally, patients to disclose the reason for seeking abortion services, which is a very odd thing in my mind, because of course, from a public health perspective and from a public policy perspective, it really is important to know, why are women seeking this? Is it a lack of adequate public support for pregnant women and their children? Or is it something different? Is it coercion? Is it we know that abortion and intimate partner violence are paired. And so it seems very odd to me on that. So the bill prohibits various limitations, but here's the kicker. Let us go to that highlighted part at the bottom of the screen. The Department of enjoin a limitation or restriction that's prohibited in this bill. And it requires the government defending such a limitation to show that it, one, significantly advances the safety of abortion services or patient health, and two, such advancement cannot be met by less restrictive measures. In fact, it completely eliminates any consideration of the potential human life, which under current Supreme Court precedent can be a significant, a substantial state interest in weighing whether or not the regulation at issue is actually a substantial burden. So when they say we're only codifying Roe, that's simply a false statement. That's not true. Finally, ratification of the Equal Rights Amendment. The Equal Rights Amendment that's being litigated in courts right now originated in 1972. It's a very simple amendment. It simply says equality under the law shall not be denied or abridged by the United States or any state on account of sex, and that Congress will have the power to enforce it, and the amendment will take effect after the date of ratification. But the following is proposed and shall be valid for all intents if it is ratified by the legislatures of 3/4 of several states within 7 years from the date of its submission by the Congress. So the date at which the ERA expired was March 22, 1979. Now, history is not simply that is not that simple. So it was reintroduced in 1983, followed word from word, the text of the 72 amendment. And during that hearing, Congressman Sensenbrenner cited the legal analysis of the Library of Congress that said that the proposed ERA on the legality of abortion would in fact overturn the Hyde Amendment and subject abortion regulations to strict scrutiny. Accordingly, Representative Sensenbrenner offered an amendment to make it abortion neutral. Simply, this law is not this amendment, this part of the Constitution, if enacted, simply does not speak to abortion. And yet, when the proponents of the legislation were asked on the floor of Congress, they were told, well, it'd be up to the federal courts to make that decision. In other words, they refused to confirm that it was intended to be and that would indeed be abortion neutral. So where are we on the ERA? And this is part of the reason I was revising this. Earlier this month, we had a decision in a case where 3 states had sought to compel the archivist of the United States government, who actually is the one who puts these amendments into the US Code, to compel him to include the ERA because it had reached the critical number of ratifications, but not by 1979, not by an extension that had been authorized by Congress, but simply it had reached the magic number. And you have, in my opinion, a very fine district court opinion saying, no, I'm sorry, it's expired. And I would note, even Justice Ginsburg, when queried about this before her death, said, it is expired and you simply need to pass a new amendment through Congress and put it before the states. And yet, notwithstanding multiple efforts to do that, such a new amendment proposal has not been passed by Congress. So what happened yesterday? Well, by a vote of 222 to 204, the US House passed a resolution that would remove the deadline for states to ratify and effectively would put it into effect. We'll see whether it passes the Senate. But given the election results in 2020, quite possibly it will. State and federal courts have concluded that state ERAs have, in fact, included abortion as a matter of equal protection. That includes Connecticut, Alaska, Arizona, Indiana, and the states listed here. So we have 3 possible codifications, 2 indirectly, but clear, and 1 taking it head on. You've got the Equality Act, you've got the ERA, those are the 2 indirect, and then you've got the Women's Health Protection Act, which will again be reiterated. Looking at the numbers in Congress, I don't think it's an idle threat. In fact, I think it's quite possible that Joe Biden will be successful in getting that passed. And here's the interesting thing. When you look at abortion jurisprudence across the country and in the US Supreme Court, it is always state statutes that get struck down under Roe and Casey. It's not federal statutes. So if Congress speaks, it may in fact be successful. So with that, I would like to mention that you have the resolution. This is now passed. Those are the resolutions. And I'd like to open the floor to whatever questions and whoever the moderator is. Thank you.
Thank you so much, Professor Collett. Your talk was wonderful, and we really appreciate you coming out today to speak with us. I will go ahead and just field a couple questions. The first one, actually, I had a question for this event. Could you speak a little bit about the law that was recently passed in Arkansas, signed by Governor Hutchinson, nearly banning all abortions, or a good number of them at least?
That legislation was motivated by the belief that you can't get Roe reversed unless you actually take it head on. I think that's a false premise. As I indicated, I think Dobbs versus Jackson would do the job. I think June Medical could have done the job. So anytime a lower court relies on Roe and Casey, I think that gives the occasion for the court to reverse that precedent. But I think it also, the Arkansas law, like similar laws, whether we're talking about heartbeat legislation or whether we're talking about 15-week bans or even the pain-capable child bans, which are only 21-week bans, I think all of that legislation is both intentional for the state to take a position, because we have what are called trigger laws in many states that simply say if Roe is reversed, abortion will become illegal in the state, or if Roe is reversed. Now, are those automatic? Typically, like all good lawyers, the question will be, well, has Roe really been reversed? And it's referred to courts and it's referred to commissions. But I think that's what's happening. Arkansas wants to be on record saying, we think that this is bad federal constitutional law and we want you to change it. And here's an opportunity for you to do it.
Wonderful, thank you. A follow-up to that, could you speak to, well, actually, I'll just read off the question. Are the quote aggressive originalist findings of John Finnis and Josh Craddock that hold that the 14th Amendment requires recognition of a fetus's personhood incompatible with an incrementalist strategy? So something like chipping away at Roe with heartbeat bills or things like that.
No, I understand. We have a First Things reader revealed in the audience, and I'm a fan myself. I should, though, tell you, for purposes of transparency, I am co-counsel in a case right now in the state of New York in federal courts that is attacking the Reproductive Health Act. It is a more limited attack. We are arguing that when the Reproductive Health Act that was passed a couple of years ago by New York that legalized abortion through all 9 months and decriminalized the killing of a viable unborn child, we are arguing that that's unconstitutional and that it places a mantle of authority around those who would assault victims of domestic violence and other forms of assault, resulting in the death of this child, and that child has constitutional stature of some sort. So it's not as aggressive as John Finnis's argument or Mike Paulson's argument in the plausibility of personhood. It is we believe, we are responding to a motion to dismiss at the moment, but we believe that there is sound legal precedent for the idea of at least the viable child. the option of abortion ought to be off the table. John Finnis takes the other view, but if you want to read a critique of that from someone sympathetic, I would suggest you go to NRO for Ed Whelan, who is pro-choice, nobody can doubt it, pro-life, nobody can doubt it, but he takes on Finnis's historical argument. So it'll be interesting to see. Like I said, we are taking the incremental approach that when a child can be born alive and the woman can terminate her pregnancy, which is what the court has always defined abortion as, without the death of the child, that the state can no longer make abortion available to her. It must limit the option to early induction.
Wonderful, thank you. The next question. Professor Jared Bradley has suggested that a leading effect of constitutional conservatism is, tragically, to make certain that if the new Democratic Congress codifies Roe, the Supreme Court will have rendered itself helpless to resist it. Do you agree?
Well, at that point, then John Finnis is our best defense. Perhaps our New York case, if we're successful all the way up to the U.S. Supreme Court. But as I mentioned in my presentation, the Hyde Amendment has survived, the federal partial birth abortion amendment. Every time the Supreme Court has looked at federal legislation as opposed to state legislation, it has sustained it. But just compare Gonzalez v. Carhart versus Stenberg v. Carhart, and you see the difference right there. So I think Jerry has good cause for his concern. And then all our eggs are going to be in the Finnis-Paulson basket. No pun intended, or committed probably.
Wonderful, thank you. And I know that in your biography, you mentioned that you had worked for Representative Ron Paul. I know that Senator Rand Paul has introduced, or I believe has considered introducing legislation to add a constitutional amendment protecting life. Do you think that that is an option, is a viable option?
Again, we've been trying to do that from 1973 forward. And part of the problem is, for both sides, when we're talking about constitutional amendments, is it requires 2/3. And so even if we were to recapture our majority in the Senate and perhaps, and yes, did I just reveal my party affiliation? I did. But even if we were to recapture the Senate and the House collectively, it would be a very remarkable situation where we were able to command 2/3. Now, the interesting question would be, will we see a political realignment of the Democratic Party? Because the Democratic Party, I have friends who are on the national leadership of Democrats for Life. And they continue to say that the majority of Democratic voters are not nearly as lockstep with the national leadership about abortion is a major issue and that abortion through all 9 months is important. So as a lawyer, I have no expertise in predicting those sorts of things.
Wonderful, thank you. Our next question. Codification has second order implications that I haven't seen addressed too often. If the court does end up overturning Roe, what would be the congressional authority? Would it be something like commerce?
That's a wonderful question. And of course, that'll be our first attack on the Women's Reproductive Health Act. So it kind of depends on how they do it, right? The Equality Act has a different, if you will, constitutional history or constitutional pedigree, as does the ERA. And so I think it really depends on, I do believe as a law professor with some expertise, I do believe the Women's Reproductive Health Act will not survive. I don't think there's adequate Commerce Clause support for that. But the other two would be a more difficult and interesting challenge.
Wonderful, thank you. We have 2 more questions, if that's all right with time.
I'm delighted.
Wonderful. Given Justice Gorsuch's ruling in Bostock, how confident are you that he would vote to overturn Roe?
Well, there we have it, don't we? I love these questions. Your students are obviously very well trained in constitutional law, and I admire the questions I'm getting. Thank you. But I will say Bostock gives me pause and is part of the pattern to me of him following the lead of the chief. So that's where I find the Biden statement so interesting, because I think if he actually thought that overturning Roe would leave those whose political beliefs differ, and I actually do believe that Chief Justice Roberts would be happy if Roe had never been decided the way it came out. So I don't think it's fervor and conviction in the way that Ginsburg's was, or even, you know, Justice Sotomayor, or Breyer for some reason. But having said that, I think he is very concerned about the argument that shifted Kennedy, right? That, oh, the public outcry and the politicization of the court. Now, I have to say, I think you're rather naive if you don't think that's the American perception anyway. And I don't think Chief Justice Roberts is naive. But he will take Gorsuch with him, I'm pretty sure.
Gotcha. Thank you. And then we have one last question. This comes from one of our first-year students. I've heard a lot of SCOTUS commentators speculate that it's more likely that the scope of abortion regulations foreclosed by Casey gets pared back than that Roe gets outright overturned. Do you think that's true given the new appointees?
Well, that's our entire premise in our New York case, that the vast majority of Americans, when in a properly constructed survey, don't think that you ought to have an abortion for any reason after viability. They do if they actually understood the dangers. I mean, the abortion industry's mantra is abortion gets more and more dangerous every week that passes, and that's true. And so at some point, childbirth is a safer option, and post-viability takes that position. And if we see abortion as the right to terminate a pregnancy, not the right to kill a child, but the right to terminate a pregnancy, we can accommodate that with early delivery. So we'll see. Would I be thrilled if our case went away because Dobbs v. Jackson Women's Health case was accepted and they reversed Roe on our march out of New York to Washington, D.C.? I would be delighted. I would be dancing in the streets. But if not, our position is that we think the court is ripe for a challenge, at least as to post-viability.
Wonderful. That concludes all of our questions. Professor Collett, thank you so much for your wonderful talk today. This has been one of our best attended events, and I can speak for our entire chapter that we really appreciate you coming to address our group today.